we're about to get into tonight. How is it? How you doing, everybody? I'm doing great. Thank you for asking. We got our work cut out for us. There's only one thing I want to talk about, and we will not waste any fudging time. All right, there it is. Let's read it. Let me find a better one. Nope. Nah. That works. Hey everybody, welcome to a layman attempts to read this Supreme Court decision overturning Roe versus Wade, apparently. Let's not hesitate, we'll just jump right into it. So what's this? Thomas E. Dobbs, State Health Officer of the Mississippi Department of Health, end all. Petitioners versus Jackson's Women's Health Organization, end all. On writ of certiorari to the United States Court of Appeals for the Fifth Court, February blank 2022. Justice Alito delivered the opinion to the court. Abortion prevents a profound moral issue on which Americans hold sharply conflicting views. Some believe fervently that a human, let's be honest guys, if we found life on Mars, a single cell, we'd say it's life. Some believe fervently that a human person comes into being at conception and that abortion ends an innocent life. Others feel just as strongly that any regulation of abortion invades a woman's right to control her own body and prevents women from achieving full equality. Still, others in a third group think that abortion should be allowed under some, but not all circumstances. And those within this group hold a variety of views about particular restrictions that should be imposed. For the first 185 years after the adoption of the Constitution, each state was permitted to address this issue in accordance with the views of its citizens. What's wrong with that? Yeah, like little laboratories of democracy, right? Oh, how horrible. Then in 1973, this court decided, so what's that, 50 years ago? This court decided that Roe versus Wade, even though the Constitution makes no mention of abortion, the court held that it confers a broad right to obtain one. It did not claim that American law or the common law ever recognized such right, and its survey of history ranged from constitutionally irrelevant discussions of abortion in antiquity to plainly incorrect. Its assertion that abortion was probably never a crime under common law. After cataloging a wealth of other information having no bearing on the meaning of the Constitution, the opinion concluded that the number of set of rules, much like those might be found in a statute enacted by a legislature. What? The opinion concluded with a number set of rules. Like, yeah, it's weird that Roe vs. Wade has rules like his legislature, because that's pretty much what it is. We were legislating from the bench. Leftists cling to the Supreme Court decision because they know Congress would never pass that law as a civil right. You are right, man. You are right. Let me get some chat on the screen, though. Here we go. Rad chat. There we go. Thank you for joining me in chat, you guys. Please like, subscribe, share the stream. Go to YouTube, share. It really helps. Activist judges, precisely. Under this scheme, each trimester of pregnancy was regulated differently, but the most critical line was drawn at roughly at the end of the second trimester, at which time corresponded to the point at which a fetus was thought to achieve, quote, viability, i.e. the ability to survive outside the womb. Although the court acknowledged that states had a legitimate interest in protecting potential life, it found that this interest could not justify any restrictions on pre-viability abortions. The court did not explain the basis for this line, and even abortion supporters have found it hard to defend Roe's reasoning. One prominent constitutional scholar wrote that he would, quote, would vote for a statute very much like the one the court ended up drafting, end quote, if he were, quote, a legislature, end quote. But his assessment of Roe was memorable and brutal. Roe was not a constitutional law at all and gave almost no sense of the obligation to try to be. Let me take a drink here. I've been well. Thank you for joining me. Thank you for asking. Actually, extremely well. Anyways, enough about me. At the time of Roe, 30 states still prohibited abortion at all stages. So, we're giving 30 states back their right to be independent laboratories of democracy again. In the years prior to that decision, about a third of the states had liberalized their laws, but Roe abruptly ended that political process. It imposed the same highly restricted regime on the nation. It effectively struck down the abortion laws of every single state. As Justice Brian White aptly put it in his dissent, the decision represented the, quote, exercise of raw judicial power, end quote. It sparked a national controversy that think about it though. How is it that leftists love using the power of government to the full force to kill babies? That's where they came out the strongest. Oh, sorry, I'm inserting my opinion. It sparked a national controversy that has embittered our political culture for half a century. Eventually, in Planned Parenthood of Southeastern Pennsylvania versus Casey, the court revisited Roe, but the members of the court split three ways. 2 justices expressed no desire to change Roe in any way. 4 others wanted to overrule the decision entirely, and 3 remaining justices signed the controlling opinion and took a third position. Their opinion did not endorse Roe's reasoning, and it even hinted at one or more of its authors having reservations about whether the Constitution protects the right to abortion. Reservations might be a line directly from there. We have reservations about but the opinion concluded that stare decisis, that is, which calls for prepositions to be followed in most instances, required adherence to what Roe called central holding, that states may not constitutionally protect fetal life before viability, even if the holding was wrong. So that's when after Roe v. Wade, we started getting all this viability shit. When does viability start? Viability starts kept getting pushed back as science advanced and whatnot. Even that holding was wrong. Anything less, the opinion claimed anything less would undermine the respect of this court and of the rule of law. Right, Disavowed podcast. It's kind of interesting to see something like this happen. It's kind of breaking. It's huge. Paradoxically, the judgment in Casey did a fair amount of overruling. Several important abortion decisions were overruled in toto. I don't know what that means. And Roe itself was overruled in part. Is toto another way of saying total? In toto? I gotta Google this. Tutu. I'm getting toilets. Defined. Tutu. A young one? Okay. Casey threw out Roe's trimester scheme and substituted a new rule of uncertain origin, under which states were forbidden to adopt any regulation that imposed an undue burden. Oh yes, I remember that line, the undue burden line, on a woman's right to have an abortion. The decision provided no clear guidance about what the difference between a due and undue burden was. Yeah, good job, justices. He's kind of shitting on the past decision. But the 3 justices who've authored the controlling opinion called the contending sides of a national controversy call the contending sides of a national controversy to end their national division by treating the court's decision as a final settlement of the question of the constitutional right to abortion. As has become increasingly apparent in the intervening years, Casey did not achieve that goal. Americans continue to hold passionate and widely divergent views on abortion, and states and legislatures have acted accordingly. Some have recently enacted laws allowing abortion with few restrictions at all stages of pregnancy. Others have tightened restrictions on abortions, beginning well before viability. In this case, 26 states have expressly asked the court to overrule Roe versus Casey. That's the majority technically, right? And allow states to regulate or prohibit pre-viability abortions. Before us now is one such law. The state of Mississippi asked us to uphold the constitutionality law that generally prohibits an abortion after the 15th week of pregnancy, several weeks before the point at which a fetus is now regarded as viable outside the womb. In defending this law, the state's primary argument is that we should reconsider and overrule Roe versus Casey, and once again allow each state to regulate abortions as its citizens wish. On the other side, respondents and the Solicitor General, the devil, ask us to reaffirm Roe and Casey, and they contend that the Mississippi law cannot stand if we do so. Allowing Mississippi to prohibit abortions after 15 weeks of pregnancy, they argue, will be no different than overruling Casey and Roe entirely. Brief for Respondent 43. They contended that, quote, no half measures, end quote, are available, and that we must either reaffirm or overrule Roe and Casey. Yeah. Oof. They put a gun to our head. Let me read some chat a little bit. I read a quote from Cicero. Another thing, Auto Rocks, is I listened to the fall of the Roman Empire, and their Senate just stopped passing laws. Their government became useless. It became just, they were ineffective. They wouldn't do anything. Yeah, lots of similarities between the fall of the Roman Empire and what we're doing right now. Anyways, the decadence before the collapse, right? Anyways, we hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion. No such right is implicitly protected by any constitutional provisions, including the one on which the defenders of Roe v. Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution. But any such right must have deep rooted in this nation's history and tradition, and implicit in the concept of ordered liberty. Okay. The right to an abortion does not fall from this category. Oh, boom, snap. Until the latter part of the 20th century, such a right was entirely unknown in American law. Indeed, when 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. No day after pills. The abortion right is also critically different from any other right that this court has held to fall within the 14th Amendment's protection of liberty. Roe's defenders characterize the abortion right as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage. But abortion is fundamentally different. As Roe and Casey acknowledged, because it destroys what those decisions called fetal life and what the law now before us describes as unborn human being. Stare decisis. So I'm trying to understand what they're saying here. Roe's defenders characterize that the abortion right as similar to the right is recognized in passages involving Yeah, they're being their degeneracy, okay? Abortion's degenerate like these other degenerate things. But abortion is fundamentally different, as Roe and Casey acknowledged, because it destroys what is those decisions have called fetal life, and what the law now before us called unborn human beings. Stare decisis is the doctrine in which Casey's controlling opinion is based does not compel unending adherence to Roe's abuse of judicial authority. Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. And far from bringing about a national settlement of the abortion issue, Roe and Casey have inflamed debate and deepened division. I should do a regular show. I've been traveling and doing stuff. Jet setter. Check out my passport, yo. It is time to heed the Constitution and return to the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to be resolved like most important questions in our democracy by citizens trying to persuade one another, then voting. Casey. This is what the Constitution and the rule of law demand. The law at issue in this case, Mississippi's Gestational Age Act, contains this essential provision. Quote, except in medical emergency or in the case of severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. They just call them unborn human beings. That's so great. They're not called fetuses anymore. It's unborn human beings. Oh my God, the unborn human beings. That's what we're gonna call them from now on, okay? Unborn babies, unborn human beings. All right, the unborn. Ooh, that sounds kind of creepy. Thank you. To support this act, the legislature made a series of factual findings. It began by noting that at the time of enactment, only 6 countries besides the United States permitted non-therapeutic or elective abortion on demand after the 12th week of gestation. So what? Only 6 other countries. Now at the time of our nation's founding, we were the only country that had a right to free speech and vote. Anyway, so that doesn't mean anything. The legislature then found that at 5 or 6 weeks gestational age, an quote unborn human being's heart begins beating, end quote. You're going to keep referring to them as unborn human beings. At 8 weeks, the unborn human beings begins moving to the womb. At 9 weeks, all basic physiological functions are present. At 10 weeks, vital organs begin to function, and hair, fingernails, toenails begin to form. At 11 weeks, quote, an unborn human being's diaphragm is developing, and he or she may move about freely in the womb. At 12 weeks, the unborn human being has taken to the human form in all relevant aspects. Quoting Gonzalez there, it found that most abortions after 15 weeks employ, quote, dilation and evacuation procedures, which involve the use of surgical instruments to crush and tear the unborn child. That's gross, man. It concluded that the intentional commitment of such acts for non-therapeutic or elective reasons is a barbaric practice, dangerous for the maternal patient and demeaning to the medical profession. God bless you. That clap. It is. It is a barbaric practice, man, and it is demeaning to the medical profession. I could not agree more to that sentiment. Do no harm. We're tearing apart and crushing a perfectly healthy life. Do no harm. Those doctors, man, what is wrong with them? Yeah, right? The Hippocratic Oath can just get effed, apparently. Respondents are do no harm. There's the whole hormones to children issue on that too, but whew. Anyways. Respondents are an abortion clinic, Jackson's Women's Health Organization, and one of its doctors. On the day the Gestational Age Act was enacted, respondents filed suit in federal court against Mississippi's officials, alleging that the act violated the court's precedent establishing a constitutional right to abortion. The court granted summary judgment in favor of the respondents and permanently enjoined enforcement of the act, reasoning that viability marks the earliest point at which the state's interest of fetus life is constitutionally adequate to justify a legislative ban on non-therapeutic abortions. That 15 weeks gestational age is prior to viability, the Fifth Circuit affirmed. We granted a certiorari to resolve the question whether all pre-viability prohibitions on elective abortions are unconstitutional. And that's kind of the central question right there. And if that question actually kind of tears apart Roe versus Wade, though, because if you say, yeah, pre-viability elective abortions are, you can prohibit those, then yeah, you just overturned Roe versus Wade. See you guys. Have a good night. The petitioner's primary defense on Mississippi's Gestational Age Act is that Roe and Casey were wrongly decided and that the act is constitutional because it satisfies rational bias review. Brief for, I wouldn't have guessed that. I don't even know what that means. Brief for petitioners 49. Respondents answer that allowing Mississippi to ban pre-viability abortions will be no different than overruling Casey and Roe entirely. Good. They tell us that no half measures are available. We must either reaffirm or overrule. They're the ones who put it. It was probably the respondents who did it. They caused this to get overturned. If they told the judge, you gotta no half measures. You have to rule in favor of us because they didn't want to lose anything. They didn't want to get any ground to them. Well, now you lost it entirely. Congratulations. We begin by considering the critical question whether the Constitution, properly understood, confers a right to obtain an abortion. No, it doesn't. Skipping that question, the controlling opinion in Casey reaffirmed Roe's central holding based solely on the doctrine of stare decisis. But as we will explain, proper application of stare decisis required an assessment of the strength of the grounds on which Roe was based. See infra. We therefore turn to the question that the Casey plurality did not consider, and we will address that question in 3 steps. First, we will explain the standard that our cases have used in determining whether 14th Amendment's reference to liberty protects a particular right. Second, okay, hold on. We'll examine whether the standard our cases have used. We're going to look at standards, okay? Second, we will examine whether the right at issue in this case is rooted in our nation's history and tradition. It's not. And whether it is an essential component of what we have described as an ordered liberty. Ordered liberty would mean no disgusting, horrible, barbaric practices. Finally, we consider whether a right to obtain an abortion is supported or not by other precedents. Maybe we'll skip to that third one because this is a long, man. How many pages are we in? We're 9. And I know we're going to stop at about half, maybe 2/3 through. Oh my God. How long have I been reading for? Oof. All right. Keep plowing through here. Constitutional analysis must begin with the language of the instrument, which offers a fixed standard for ascertaining what our founding document means. The Constitution makes no express reference to the right of an abortion, and therefore those who claim it protects such rights must show that the right is somehow implicated in the constitutional text. Roe, however, was remarkably loose in its treatment of the constitutional text. It held that the right to an abortion, which is not mentioned in the Constitution, is part of the right to privacy, which is also not mentioned. Oof. And that right, that privacy right, Roe observed, had been found to spring from no fewer than 5 different constitutional provisions. So that's really weird. Normally, one constitutional provision protects your right. If you're coming from 5, it kind of looks like you're more like just you're doing a laundry list approach of just throw the kitchen sink at it. The court's discussion left open at least 3 ways in which some combination of these provisions could protect the abortion right. You know, the 1st, 4th, 5th, 9th, and 14th. One possibility was the right founded in the 9th Amendment rights, preservation of a right to the people, reservation of rights to the people. Another was that the right was rooted in the 1st, 4th, and 5th Amendment, or some combination of those provisions, that this right had been incorporated into the Due Process Clause of the 14th Amendment, just as many other of the Bill of Rights provisions had been incorporated. A third part was that the 1st, 4th, and 5th Amendments played no role, and the right was simply a component of the liberty protected by the 14th Amendment Due Process Clause. Roe expressed the feeling that the 14th Amendment was the provision that did the work, and but its message seemed to be the abortion right could be found somewhere in the Constitution, and that the specifically its accusation was not the paramount importance. Okay. The Casey court did not defend this unfocused analysis, and instead grounded its decision solely on the theory that the right to obtain an abortion is part of the liberty of the 14th Amendment's Due Process Clause. We discussed this theory in depth below, but before doing so, we briefly address one additional constitutional provision that some of the respondents' amici have now offered as yet another potential home for the abortion right. The 14th Amendment's Equals Protection Clause. I'm not going to read all this. With this new theory addressed, we turn to Casey's bold assertion that the right to abortion right, is an aspect of liberty protected by the Due Process Clause of the 14th Amendment. This underlying theory on which this argument rests, the 14th Amendment, liberty, has been long controversial, but our decision has been held that the Due Process Clause protects 2 categories of substantial rights. First consists of rights guaranteed by the first 8 amendments. Those amendments originally applied only to federal government. But this court has held that the Due Process Clause of the 14th Amendment incorporates the greater majority of those rights and thus makes them equally applicable to the states. The second category, in which is the one question here, comprises a select list of fundamental rights that are not mentioned anywhere in the Constitution. In deciding whether a right falls into... Okay, there are some rights you have that are not mentioned in the Constitution. One of those, for example, is to right to parent your kids, for example. to parent your kids the way you see fit. That's like a common law, kind of obvious thing. Abortion's not so much. Anyways, in deciding whether a right falls into these categories, the court has long asked the question whether the right is deeply rooted in our history and tradition, like parenting your kids, whether it is essential to our nation's scheme of ordered liberty. And in conducting this inquiry, we have engaged in a careful analysis of the history of the right at issue. Justice Ginsburg's opinion for the court in Timms v. Indiana Supra is a recent example in concluding that the Eighth Amendment's protection against excessive fines is a fundamental to our scheme of ordered liberty and deeply rooted in our nation's history and tradition. Her opinion traced the rights back to the Magna Carta, Blackstones, and 35 of the 37 state constitutions in effect at the ratification of the 14th Amendment. See, that's a good right there. In a similar inquiry undertaken by McDonald Supra, which held that the 14th Amendment protects the right to keep and bear arms, the lead opinion surveyed the origins of the Second Amendment, the debates in Congress about the adoption of the 14th Amendment at the state constitutions, in effect when the amendment was ratified, federal laws enacted during the same time period, and other relevant historical evidence. Only then did the opinion conclude that the framers and ratifiers of the 14th Amendment counted the right to keep and bear arms amongst those federal rights necessary to our system of ordered liberty. Timms and McDonald concerned the question whether the 14th Amendment protects rights that are expressly set out in the Bill of Rights. And it would be anomalous if similar historical support were not required when a putative right is not mentioned anywhere else in the Constitution. Thus, Glucksberg, which held that the Due Process Clause does not confer the right to an assisted suicide, the court surveyed more than 700 years of Anglo-American common law tradition. At 710, and made clear that a fundamental right must be objectively deeply rooted in this nation's history and tradition. Historical inquiries of this nature are essential whenever we are asked to recognize a new component of the liberty protected by the Due Process Clause, because the term liberty alone provides little guidance. Liberty is a capacious term. As Lincoln once said, we all declare for liberty, but in using the same word, we do not all mean the same thing. In a well-known essay, Isaiah Berlin reported that historians of ideas have cataloged more than 200 different senses in which the term has been used. Wow, liberty? Damn. In interpreting what is meant by the 14th Amendment's reference to liberty, we must guard against the natural human tendency to confuse what that amendment protects with our ardent views about the liberty that Americans should enjoy. That is why the court has long been reluctant to recognize rights that are not mentioned in the Constitution, like the right to health care, or the right to housing, the right to... Sometimes the court, it has sometimes led the court to usurp authority that Congress entrusts to the people's representatives. What are we talking about here? Substantive due process has at times been a treacherous fiend for this court, and it has sometimes led the court to usurp authority that the Constitution entrusts to the people's elected representatives. As the court cautioned in Glucksberg, we must exercise the utmost care whenever we are asked to break new ground in this field. At least the liberty protected by Due Process Clause should be subtly transformed into policy preferences of the members of this court. On occasion, when the court has ignored appropriate limits imposed by respective teaching history, it has fallen into freewheeling judicial policy making that is characterized discredited decisions. Such as Lochner v. New York. The court must not fall. I kind of curious what that one has. The Thrifty Lounge. There is no term of abortion in the Constitution. Exactly. Thanks for joining me. Please click like. The court must not fall prey to such unprincipled approach. Instead, guided by the history and tradition that map the essential components of our nation's concept of ordered liberty, we must ask what our nation's concept of ordered liberty. We must ask what the 14th Amendment means by the term liberty. We must engage in that inquiry in the present case, and the clear answer is that the 14th Amendment does not protect the right to an abortion. That is true regardless of whether we look at the amendment's due process clause or its privileges or immunities clause. Some scholars, justices, have maintained that the privileges and immunities clause in its provision of the 14th Amendment guarantees substantive rights. We're going to continue on here. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. Zero. None. Wow. Look at this. This sounds like a Twitter post. Seriously. Zero. None. We're going to relay this again. Until the latter part of the 20th century, there was no support in American law for constitutional right to an abortion. Zero. None. No state constitutional provision had recognized such right. Until a few years before Roe was handed down, no federal or state court had recognized such right. Nor had any scholarly treatises of which we are aware. And although law review articles are not reticent about advocating for new rights, the earliest article proposing a constitutional right to an abortion that has come to our attention was published only a few years before Roe. Not only was there no support for such constitutional rights shortly before Roe, but abortion has long been a crime in every single state. It was the exact opposite of a right. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. American law followed the common law until a wave of statutory restrictions in the 1800s expanded the criminal liability for abortions. By the time of adoption of the 14th Amendment, 3/4 of the states had made abortion a crime at any stage of pregnancy, and the remaining states would soon follow. Roe either ignored or misstated this history, lied, and Casey declined to reconsider Roe's faulty historical analysis, lied. It is therefore important to set the record straight. We begin with the common law, under which abortion was a crime at least after quickening, i.e., the first felt movement of the fetus in the womb, which usually occurs between the 16th and 18th week of pregnancy. The eminent common law authorities, Blackstone, Coke, Hale, and the like, all described abortion after quickening as criminal. Henry de Braction's 13th century treatise explained that if a person has struck a pregnant woman or has given her poison whereby he has caused an abortion, and if the unborn human, if the foetus has already been formed and animated, and particularly if it to be animated, he commits homicide. So yeah, it counts when you kill a pregnant lady. It counts to when you double homicide if you kill a pregnant lady and her baby. That's an old law. I don't know how they ignored this. Where's the 24 on here? The exact meaning of quickening is subject to some debate. Okay, all right, fine. Quickening consistently meant the woman's perception of fetal movement. We need not wade into this debate. First, it suffices for present purposes to show that abortion was criminal by at least 16 to 18 week pregnancy. Second, as we will show during relevant period surrounding the enactment of the 14th Amendment, the quickening distinction was abandoned as states criminalized abortion at all stages of pregnancy. The quickening. I'll only read the first part of this. The exact meaning of quickening is subject to some debate. Compare brief for amici curiae scholars of jurisprudence John M. Finnis and Robert P. George in the Sunport Petitioners. A quick child meant that a live child, under the era's outdated knowledge of embryology, a fetus was thought to become quick at around 6 weeks of pregnancy. With brief for amici curiae American Historical Association and an organization of American historians, quickening consistently meant a woman's perception of fetal movement. Today I learned. Sir Edward Coke's 17th century treaty likewise asserted that an abortion was a quick child was murder if the child was born alive, and a great misprision if the child death in her body. These extra E's. Institutes of Law in England. 2 treaties by Sir Matthew and Hale likewise described abortion of a quick child who died in the womb as a great crime and a great misprison. See Hale, all right. And writing near the time of the adoption of our Constitution, Blackstone explained that abortion of a quick child was the ancient law homicide and manslaughter, citing Brackton, and at least a very heinous misdemeanor, citing Coke. English cases dating all the way back to the 13th century. Wow, that's corroborate this treatise's statements that abortion was a crime. That's common law for you, baby. And in 1732, 13th century, man, it's almost the Magna Carta era. That's some historical crap. In 1732, for example, Eleanor Baer was convicted of destroying the foetus in the womb of another woman and thereby causing her to miscarry. Whatever he did. The crime and another misdemeanor, Baer was sentenced to. It was 2 days in pillory and 3 years imprisonment. Oh my God. That is a old-fashioned sentence, man. 2 days in pillory, 3 years in prison for causing a miscarry. Although pre-quickening abortion was not itself considered homicide, it does not follow that abortion was permissible at common law, much less that abortion was a legal right. Quite the contrary. In 1732, case I mentioned above, the judge said that if the charge of abortion, not mention of quickening, no mention of quickening, the charge of abortion, that he had never met a case so barbarous and unnatural. Similarly, an indictment from 1602, which did not distinguish between pre-quickening and post-quickening abortion, described abortion as pernicious and against the peace of Our Lady, the Queen, her crown, and dignity. It's against dignity. That the common law did not condone even pre-quickening abortions. It is confirmed by what one might call proto-felony murder rule. Proto-felony murder rule. Hale and Blackstone explained a way in which a pre-quickening abortion could rise to the level of a homicide. Hale wrote that if a physician gave a woman a child and a potion to cause an abortion, the woman died, it was murder because the potion was given was unlawful to destroy her child within her. Wait, hold on. And it was murder. As Blackstone explained, to be murder, a killing has to be done with malicious aforethought, either expressed or implied. In the case of an abortionist, Blackstone wrote, the law will imply malice for the same reason that it will imply malice if a person is intended to kill one person accidentally killed a different person. If one shoots at A and misses him but kills B, this is murder because of the previous felony intent, which the law transfers from one to another. The same case whereby one lays poison for A and B against whom the prisoner had no malicious intent, takes it and kills him. Likewise, that is murder. So also, if one gives a woman with a child a medicine to procure an abortion, and it operates so violently as to kill the woman, this is murder in the person who gave it. So he's saying, if your day after pill killed a lady, you would charge them with a murder, or not the other way around. Notably, Blackstone, like Hale, did not state this proto-felony murder rule required that the woman be with quick child, only that she be with child. And it is revealing that Hale and Blackstone treated abortionists differently from other physicians and surgeons who caused the death of a patient without any intent of doing the patient any bodily hurt. These other physicians, even unlicensed, would not be guilty of murder or manslaughter, but a physician performing an abortion would, precisely because his aim was an unlawful one. In sum, although common law authorities differ on the severe punishment for an abortion committed at different points in pregnancy, none endorse the practice. Moreover, we are aware of no common law case or authority at parties, and the parties have not pointed to, that remotely suggests a positive right to procure an abortion at any stage of pregnancy. In this country, the historical record is similar. The most important early American edition of Blackstone's Commentaries reported Blackstone's statement that an abortion of a quick child was at least a heinous misdemeanor. And that edition also included Blackstone's discussion of the proto-felony murder rule. Manuals for justices of the peace printed in the colonies in the 18th century typically restated the common law on the rule of abortion. And some manuals repeated Haley's and Blackstone's statements that anyone who prescribed medicine to unlawfully destroy a child would be guilty of murder if the woman died. To unlawfully destroy the child. Whew. There are few cases available from the early colonial period corroborate that abortion was a crime. There are a few cases. Okay. In Maryland in 1652, for example, an indictment charged that a man murderously endeavored to destroy, or murderously endeavored to destroy the child by him begotten in the womb. Wow. And by the 19th century, courts frequently explained that the common law made abortion of a quick child a crime. The original ground for drawing a distinction between pre and post quickening abortions is not entirely clear, but some have attributed to the rule to the difficulty of proving that a pre quickening fetus was alive. At some point, at that time, there was no scientific methods for detecting pregnancy, its early stages, and thus one court put it in 1872, until the period of quickening, there is no evidence of life. And whatever may be said of the fetus, the law has fixed upon this period of gestation of time in which a child is endowed with life, because fetal movements are at the first clear marked and well-defined evidence of life. Because we definitely made abortion illegal up to 15 weeks because we can definitely prove it's alive. More like before that, you can't even prove there's anything in there. Now we have ultrasound, so now you can do it super early. Oh my God. The Solicitor General offers a different explanation of the bias for the quickening rule, namely that before quickening, the common law did not regard a fetus as having separate and independent existence. Brief for United States as amicus curiae 26. I don't know what that means, but the case on which the Solicitor General relies for this proposition also suggests that the criminal's law's quickening rule was out of step with the treatment of prenatal life in other areas of law, noting that too many purposes in reference to civil rights, an infant in ventre se mari is regarded as a person in being. Bunch of citations. At any rate, the original ground for the quickening rule is of little importance for present purposes because the rule was abandoned in the 19th century, and during that period, treatise writers and commentators criticized the quickening distinction as neither in accordance with the result of medical experience nor with the experiences of the common law. He described the quickening distinction as absurd and injurious. In 1803, the British Parliament made abortion a crime at all stages of pregnancy and authorized the imposition of severe punishment. See Lord Ellenborough's Act. One scholar has suggested that Parliament's decision may partly have been attributable to the medical man's concern that fetal life should be protected by the law at all stages of gestation. In this country, during the 19th century, the vast majority of states had enacted criminal statutes criminalizing abortion at all stages of pregnancy. By 1868, when the 14th Amendment was ratified, 3/4 of the states, 28 out of 37, had enacted statutes making abortion a crime, even if it had been before quickening. One of the 9 states that had not been criminalized abortion at all stages, all but one did so by 1910. So they eventually got around to it. The trend in the territories that would become the last 13 states was similar. The trend, let's see. All of them criminalized abortion at all stages of pregnancy between 1850 and 1919. So you can see the appendix in the back. It's like the second half of this PDF. It's all just a bunch of all the states banning abortion. By the end of 1950, according to the Roe Court's own count, statutes in all but 4 states and the District of Columbia prohibited abortion, however, whenever performed, unless done so to save or preserve the life of the mother. This overwhelming consensus endured until the day Roe was decided. At that time, also by Roe's court's own count, a substantial majority of states, 30 states, still prohibited abortion at all stages except to save the life of a mother. And although Roe discerned a trend towards liberalization in about one third of the states, those states still criminalized some abortions and regarded them more stringently than a Roe would allow. In short, the court's opinion in Roe itself convincingly refutes the notion that the abortion liberty is deeply rooted in the history or tradition of our people. So those justices were lying when they said it back then. The inescapable conclusion is that the right to abortion is not deeply rooted in our nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on pain of crime punishment persists from the earliest days of common law until 1973. The court in Roe could have said abortion exactly what Glucksberg said as assisted suicide. The attitudes towards abortion have changed since Brighton, but our laws have consistently condemned and continue to prohibit that practice. The respondents and their amici have no persuasive answer to historical evidence. Neither respondent nor the Solicitor General disputes the fact that by 1868, the vast majority of states criminalized abortion at all stages of pregnancy. See the brief for petitioners. States prohibited abortion before quickening. Oral argument. Instead, respondents are forced to argue that it does not matter that some states prohibited abortion at the time of Roe. It does not matter that some states prohibited abortion at the time of Roe was decided or when the 14th Amendment was adopted. But that argument flies in the face of the standard we have applied in determining whether an asserted right that is nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment. And she's like, well, it doesn't matter if it's, or does it say it does not matter that some states prohibited abortion at the time of Roe? Yes, it does. That's what you need. Not only are respondents and their amici unable to show that the constitutional right to an abortion was established when the 14th Amendment was adopted, but that they have found no support for the existence of an abortion right that predates the latter part of the 20th century. No states, constitutional provisions, no statute, no judicial decision, no learned treatise. The earliest source called to our attention are a few district court and state court decisions decided shortly before Roe and a small number of law review articles from the same time period. A few respondents amici muster historical arguments, but they are weak. The Solicitor General repeats Roe's claim that it is, quote, doubtful abortion was ever firmly established as common law crime, even with respect to the destruction of a quick fetus, end quote. That's a lie then. Brief for United States amici. But as we have seen, great common law authorities like Bryston, Coke, Hale, and Blackstone all wrote that a post-quickening abortion was a crime. and a serious one at that. Moreover, Hal and Blackstone asserted that even when a pre-quickening abortion was unlawful, and that as a result, an abortionist was guilty of murder if a woman died from the attempt. Instead of the following these authorities, Roe relied largely on 2 articles by a pro-abortion advocate who claimed that Koch had intentionally misstated the common law because of his strong anti-abortion views. These articles have been discredited, and it has come to light that even members of Jane Roe's legal team did not regard them as serious scholarship. An internal memorandum characterized this author's work as donning the guise of an impartial scholarship while advocating the proper ideological goals. Continued reliance on such scholarship is unstoppable. The Solicitor General's next suggests that history supports the abortion right because common law's failure to criminalize abortion before quickening means that at founding and for decades thereafter, women generally could terminate a pregnancy, at least in its early stages. But they didn't know they were pregnant. But the instance of quickening was not universal. Regardless, the fact that many states in the late 18th century and 19th century did not criminalize pre-quickening abortions does not mean anyone thought the states lacked the authority to do so. When legislature began to exercise its authority as the century wore on, no one, as far as we are aware, argued that the laws enacted violated a fundamental right. That is not surprising since common law authorities had repeatedly condemned abortion and described it as unlawful, an unlawful act without regard to whether it occurred before or after quickening. Another amicus brief relied upon by the respondents tries to dismiss the significance of state criminal statutes that were in effect at the time of the 14th Amendment by suggesting that they were enacted for illegitimate reasons. It doesn't matter. They were enacted. According to this point, which is based almost entirely on statements made by one prominent proponent, important motives for the law were the fear that the Catholic immigrants were having more babies than Protestants, and that the availability of abortion was leading to white Protestant women to shirk their maternal duties. Before amicus curiae. Based. Resort to this argument is a testament to the lack of any real historical argument for the right that Roe and Casey recognize. This court has long disfavored arguments based on the alleged legislative motives. The court has recognized that inquiries into legislative motives are hazardous matter. Even when an argument about legislative motive is backed by statements made by legislators who voted for a law, we have been reluctant to attribute those motives to the legislative body as a whole. What motivates one legislator to make a speech about a statute is not necessarily what motivates scores of others to enact it. Here, the argument about legislative motive is not even based on statements by legislators, but on statements made by a few supporters of the new 19th century abortion laws. And it's quite a leap to attribute these motives to all legislators whose votes were responsible for the enactment of those laws. Recall that at the time of the adoption of the 14th Amendment, 3/4 of the United States had adopted statutes criminalizing abortion, usually at all stages of pregnancy, and that far and that from the early 20th century until the day of Roe was handed down, every single state had such laws on its books. Are we to believe that hundreds of lawmakers whose votes were needed to enact these laws were motivated by hostility to Catholics and women? Yes. There is ample evidence that the passage of these laws was instead spurred by a sincere belief that abortion kills a human being. Many judicial decisions from the late 19th century and the early 20th century made this point. One may disagree with this belief, not our decision, but it's not our. No, wait. One may disagree with this belief, and not our decision. It's based. I'm not going to read the interest. But even Roe and Casey did not question the good faith of abortion opponents. Men and women of good conscience can disagree about the profound moral and spiritual implications of terminating a pregnancy, even at its early stages. We see no reason to discount the significance of state laws in question based on these decisions about legislatures' motives. C1. Sup, Tony Tran? Just hanging out, man. Reading this Supreme Court opinion that overturned Roe versus Wade. It's pretty good so far. Oh, man. I need to clear my nose somehow. I think I have this giant nose. You think I could breathe easy? No, I can't. Instead of seriously pressing the argument that abortion right itself has deep roots, supporters of Roe and Casey contend that the abortion right is an integral part of broader entrenched right, the right to privacy. Casey described it as freedom to make intimate personal choices that are central to the personal dignity and autonomy. Casey elaborated, at the heart of liberty is the right to determine one's own concept of existence. What? Of meaning, of universe, and the mystery of human life. What fruity, flowery language is that? The court did not claim that this broadly framed right is absolute, and no such right would be plausible. No such claim would be plausible. While individuals are certainly free to think and say what they wish about existence, meaning universe, and the mystery of human life, they are not always free to act in accordance with those thoughts. License to act on the basis of such beliefs may correspond to one of many understandings of liberty, but is certainly not ordered liberty. Oof. Ordered liberty sets limits and defines the boundaries between competing interests. Roe and Casey each struck a particular balance between the interests of women who want abortion and the interests of what they termed potential life. But the people of various states may evaluate those interests differently. In some states, voters may believe that abortion rights should be even more extensive than the rights of Casey and Roe recognized. Voters in other states may wish to impose the tight restrictions based on their belief that abortion destroys an unborn human being. Mississippi. Our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. Nor does the right to obtain an abortion have sound basis and precedent. Casey relied on cases involving the right to marry a person of different race, the right to marry while in prison, the right to obtain contraception. See, I told you, they're all just a bunch of degenerate rights. The right to reside with relatives. See, that's more of that's kind of like paternal rights almost there. Unless that's like, ooh, what's that mean? The right to reside with relatives? I don't know what that means. The right to make decisions about the education of one's children. But not when it comes to teaching your kids about hanky-panky. The right not to be sterilized without consent. Pierce versus Society of Sisters. The right in certain circumstances not to undergo involuntary surgery. Forced administration of drugs. Is that Winston Lee? Oklahoma Wilson. Yeah, Oklahoma Skinner Wilson sterilized without consent. That's disgusting. Respondents, Solicitor General, also rely on post-case decisions like Lawrence v. Texas. The right to engage in private consensual sexual acts. The right to marry a person of the same sex. These attempts to justify abortion through degeneracy appeals to a broader sense right of autonomy and to define one's concept of existence prove too much. Those criteria, at high-level generality, could license fundamental rights to illicit drug use, prostitution, and the like. Prostitution should be legal. Same thing with the drug use. None of these rights has any claim to be deeply rooted in history. What sharply distinguishes the abortion right from the rights recognized in the cases of which Roe and Casey rely is something that both decisions acknowledged. Abortion destroys what those decisions call potential life, and the law at issue in this case regards as the life as an unborn human being. None of the other decisions cited in Roe case involve critical moral questions posed by abortion. They are therefore inopposite. They do not support the right to obtain an abortion. And by the same token, our conclusion is that the Constitution does not confer such right to undermine them in any way. In drawing this critical distinction between the abortion right and the rights of others, it is not necessary to dispute Casey's claim that the specific... Oh my God, I can't keep reading. Three. Stare decisis. Turns out they fucked up the stare decisis. So we're going to go to 4. Whoa. Is this all citations? What is this? Finally, in West Virginia, Board of Education versus Barnett, after the lapse of only 3 years, the court overruled Minersville School District versus Gobbets and held that the public school students could not be compelled to salute the flag in violation of their sincere held beliefs. Barnett stands out because nothing has changed during the intervening period other than the court's belated recognition that its early decision had been seriously wrong. On many other occasions, this court has overruled important constitutional decisions. We include a partial list in the footnote that follows. Here's the footnote. Here's the footnote. Here's the okay. 2 pages of footnote. No more abortions. No, it goes back to the states. American constitutional law, as we know it, would be unrecognizable. And this would be a different note. No justice of the court has ever argued that the court should never overrule a constitutional decision. But overruling a precedent is a serious matter. It is not a step that should be taken lightly. Our cases have attempted to provide a framework for deciding when a precedent should be overruled, and they have identified factors that should be considered in making these decisions. 5 factors: the nature of their error, the quality of their reasoning, the workability of the rules they impose on the country, their disruptive effects in other areas of the law, and the absence of concrete reliance. What? The nature of the court's error. An erroneous interpretation of the Constitution is always important, but some are more damaging than others. Oh my God. The infamous decision of Plessy v. Ferguson's was one such decision. It betrayed our commitment to equality under the law. It was egregiously wrong at the day it was decided. It should have been overruled at the earliest opportunity. Roe was also egregiously wrong and deeply damaging. For the reasons already explained, Roe's constitutional analysis was far outside the bounds of any reasonable interpretation of various constitutional provisions. Roe was on a collision course with the Constitution from the day it was decided. B. Quality of reasoning. Under our precedents, the quality of reasoning in this case has important bearing. All right, and yeah, we have great reasoning. But it failed to ground its decision in text, history, or precedent. It relied on erroneous historical narrative. It owed great attention to a preamble, presumably relied on matters that have no bearing on the meaning of the Constitution. Verse 3. Roe did not provide any cogent justification for the lines it drew. Why, for example, does a state have no authority to regulate the first trimester abortion for purpose of protecting a woman's health? The court only explanation was that mortality rates for abortion at that stage were lower than mortality rates for childbirth. But the court did not explain why mortality rates were the only factor at the stage that could legitimately consider. Many healthy and safety regulations aim to avoid adverse health consequences short of death. And the court did not explain why it departed from the normal rule that the courts defer to the judgments of legislatures in areas fraught with medical and scientific uncertainties. Yeah, I don't know why they did that, Marshall v. United States. Even more glaringly deficiencies was Roe's failure to justify the critical distinction it drew between pre- and post-viability abortions. Here is the court's explanation entirely. With respect to the state's important and legitimate interests in potential life, the compelling point is at viability. This is so because the fetus then presumably has the potential of meaningful life outside of the womb. As Professor Lawrence Tribe has written, clearly this mistakes a definition for a syllogism. Okay, Google. What's a syllogism?
According to Wikipedia, a syllogism is a kind of logical argument that applies deductive reasoning to arrive at a conclusion based on two propositions that are asserted or assumed to be true.
A syllogism. The definition of viable fetus is one that is capable of surviving outside the womb. But why is this the point at which the state's interest becomes compelling? If, as Roe held, a state's interest in protecting a prenatal's life is compelling after viability, why is the interest not equally compelling before viability? Yeah, that's a great point. Never answered. Roe did not say, no explanation is apparent. This arbitrary line has not found much support among philosophers, ethicists, who have attempted to justify a right to an abortion. Some have argued that a fetus should not be entitled to legal protection until it acquires characteristics that they regard as defining of what it means to be a person. Amongst the characteristics that have been offered are essential aspects such as of personhood, are sentience, self-awareness, the ability to reason, or some combination thereof. By this logic, it would be an open question whether even born individuals, including young children, and those afflicted of certain developmental or medical conditions, merits protections as persons. Even if one asks that view at that person who begins with certain attributes or combination of attributes is acquired, it is very hard to see why viability shouldn't mark the point at where personhood begins. By the most obvious problem with any such argument is that the viability is heavily dependent on factors that have nothing to do with the characteristics of the fetus. One is the nature of the state of neonatal care at which a particular point in time. Due to developments in new equipment, improved practices, the viability line has changed over the years. In the 19th century, a fetus may not be viable until 32 or 33 weeks after conception or even later. When Roe was decided, it was roughly 28 weeks. Today, the respondents drew a line at 23 or 24 weeks. The brief of respondents at 8. So according to Roe's logic, states now have a compelling interest to protecting fetus life of gestational age of, say, 26 weeks. But in 1973, the states did not have any interest in protecting an identical fetus? How can that be? Viability is also depends on the quality of medical facilities. Therefore, blah, blah, blah. We know about that, obviously. Viability is not really a hard and fast line. A physician determining a particular fetus' odds of surviving outside the womb must consider a number of variables, including gestational age, fetal weight, a woman's general health and nutrition, the quality of the available medical facilities, and other factors. It is thus only with difficulty that a physician can estimate the probability of a particular fetus' survival. And even if each fetus's probability of survival could be ascertained with certainty, settling on the probability of survival should count as viability is another matter. Is a fetus viable with a 10% chance of survival? 25? 50? Can such a judgment be made by state? Can a state specify gestational age limit that applies in all cases, or must these different questions be left entirely to the individual's attending physicians on the particular facts on the case before him? The viability line is a difficult line to follow. All in all, Roe's reasoning was exceptionally weak, and academic commentators, including those who agree with the decision of matter policy, were unsparing with their criticism. John Hart Ely famously wrote that Roe was not constitutional law and gave almost no sense of obligation to be. Archibald Cox, who served as Solicitor General under President Kennedy, commented that Roe reads like a set of hospital rules and regulations that neither historian, layman, nor lawyer would be persuaded as part of the Constitution. Archibald Cox, the role of the Supreme Court of America. Lawrence Tribe wrote that even if there was a need to divide pregnancy into several segments with lines that clearly identify the limits of government power, interest balancing of the form of courts pursues fails to justify any of the lines actually drawn. See? Workability. We're overturning Roe versus Wade, baby. We're keeping this baby alive. E. Will we skip over D? D. That was a short one. The effects of case law. Roe and Casey have led to distortion of many important but unrelated legal doctrines. Members of this court have repeatedly lamented that no legal rule or doctrine is safe from ad hoc nullification by the court when an occasion for its application arises in the case involving state regulation of abortion. Federal courts The court's abortion cases have diluted the strict standing for facial constitutional challenges. They have ignored the court's third-party standing doctrine. They have disregarded the standing of the standard res judicia principles. They have flouted the ordinary rules of severability of unconstitutional provisions. I don't know what any of this means. We get to the third section. 4. Having shown the additional stare decisis factors do not weigh in favor of Roe versus Casey, Roe or Casey, we must address one final argument. The argument is that the cast is different. The argument was cast in different terms, but stated simply, it was essentially as follows. The American people's belief in the rule of law would be shaken if they lost respect for this court as an institution that decides important cases based on principles, not on social or political pressures. There is a special danger that the public will perceive a decision as having been made for unprincipled reasons when the court overrules a controversial watershed decision. A decision overruling Roe would be perceived as having been made under fire as a surrender to political pressure. This analysis starts out on the right foot, but ultimately veers off course. Oh my God. I can't read anymore. I'm dying. This is too much for me. Are we done yet? We got to be getting close to done. We must now decide what standard will govern if a state abortion regulations undergo constitutional challenge and whether law before a state is appropriate standing. Under our precedents, rational basis review is the appropriate standard for such challenges. As we have explained, procuring an abortion is not a fundamental constitutional right because the right has no basis in the constitutional text. It follows that states may regulate abortion for legit inmate reasons. And when such regulations are challenged under the Constitution, the courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. That respect for the legislature's judgment applies even when the laws at issue concern matters of great social significance and moral substance. A law regarding abortion, like other health and welfare laws, is entitled to strong presumption of validity. It must be sustained if there is a rational basis on which the law could have been thought to enacted if it would serve legitimate state interests. These legitimate interests include respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety, and the elimination of particularly gruesome and barbaric medical procedures, child hormone therapy, and the mitigation of fetal pain and prevention of discrimination on the basis of blah, 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 blah. These legitimate interests justify Mississippi's act, except in medical emergency or in the case of severe fetal abnormalities. The state prohibits an abortion if the probable gestational age of the birth is 15 weeks. Mississippi legislature finding recounts that stages of human prenatal development. The legislature also found that abortions performed after 15 weeks typically use dilation and evacuation procedure, and the legislature found the use of this procedure for non-therapeutic or elective reasons to be a barbaric practice, dangerous to the medical patient and demeaning to the medical profession. These legitimate inmate interests provide a rational basis for the Judicial Age Act, and it follows the respondent's constitutional challenge must fail. We end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. We now overrule those decisions and return the authority to the people and their elected representatives. The judgment of the Fifth Circuit is reversed, and this case is remanded for further proceedings consistent with this opinion. It is so ordered. That was an hour and a half long read, and I skipped lots of it. If you guys like this type of content, leave a like down below, subscribe, share for friends. Radically Moderate over here. Man, that was tough. I'm done now. I'm tired, guys. I think I'm gonna end the fucking stream now. I'm going to bed. I'm going to bed, you guys. Good night. Take care. Keep it real.